It's the most wonderful time of the week. Welcome back to the Politics with Paul podcast with your host, Paul Rader. Merry Christmas to all of you who celebrate. Today, we're going to talk about potential term limits on the Supreme Court of the United States, or SCOTUS for short. So, earlier this month, December 2024, U.S. Senators Joe Manchin of West Virginia, who's leaving office at the end of his term in January, and Peter Welch of Vermont introduced, a resolution that calls for non-renewable 18-year terms for new U.S. Supreme Court justices, with each new term starting every 2 years, and current justices would be exempt from these terms. They being Joe Manchin and Peter Welch, called the current lifetime appointment structure polarizing and political posturing, and they also cited plummeting public confidence in the institution of SCOTUS itself. And now this is a resolution, not a bill, so passage wouldn't outright implement term limits, but rather be a formal call for amendment to the U.S. Constitution. And we'll talk a little bit more about how that process works. Now, calls for term limits on SCOTUS justices are nothing new, but there is arguably more clamoring for it to happen more recently. So, should we have term limits on SCOTUS justices? What are the arguments made for and against giving them term limits? What are the considerations that go into potentially implementing term limits? All of that and more is what we're going to talk about today. So, let's dive right in. First of all, why do SCOTUS justices have lifetime appointments? Why don't they have a fixed term? As Article 3, Section 1 of the U.S. Constitution says, the judges both of the Supreme and inferior courts, those are other federal courts that are not the Supreme Court, shall hold their offices during good behavior basically being as long as they're not doing something that's an impeachable offense. And the insight into why the framers of the Constitution ultimately decided on this is provided by Alexander Hamilton in his writing of Federalist Paper number 78. And the Federalist Papers were a series of documents from the framers, Alexander Hamilton, James Madison, and in a few cases, John Jay specifically, detailing to the public why the U.S. Constitution should be ratified to replace what was then the governing document of the United States, the Articles of Confederation. And in Federalist Paper number 78, there's a couple of quotes in particular I want to highlight. In a republic, it is a no less excellent barrier to the encroachments and oppressions of the representative body, and it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. In other words, according to Alexander Hamilton, lifetime terms would allow the Supreme Court to be impartial and resistant to any attempts at influence by Congress or the president. And then the other quote I'm going to cite here, the judiciary, from the nature of its functions, will always be the least dangerous of the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse. And in other words, that just means the judiciary is naturally the least powerful of the three branches. It doesn't have any sort of capability to enforce its rulings. It really has to rely on the executive and legislative branches to abide by what the courts say. The executive branch has the power to execute laws, while the legislative branch has the power to appropriate money, hence the executive having the power of the sword and the legislative branch having the power of the purse. But the judiciary has no power over either of these things or anything comparable. So that's the idea of the lifetime terms would be a bit of a balance to give some power over to the judiciary, the judicial branch, and try to keep the balance in the separation of powers and checks and balances. But now more and more people these days question whether the judiciary still has that insulation from partisan politics and whether they are even accountable enough for any rulings that they administer. And some political observers have been questioning it for a lot longer. But do term limits actually lead to a more independent judiciary? Does it really actually insulate them from these partisan politics that we're talking about? Does it actually make them accountable? Well, let's first compare SCOTUS with state Supreme Courts, because every state has their own Supreme Court that has a similar function to the U.S. Supreme Court. But of course, the U.S. Supreme Court, SCOTUS, is the highest court in the land. So for SCOTUS, when a justice leaves office for any reason, or they're about to leave office, so if they pass away, they get impeached, they are otherwise physically or mentally incapable of performing their duties, a president picks a new justice to replace them. And nominated justices must get a majority of the U.S. Senate to support their nomination to be confirmed to the bench. Now, unlike SCOTUS, however, almost all state Supreme Court justices have fixed terms, and most at least have what we call a mandatory retirement age. So when they hit that age, they have to leave office regardless of whether they finish their term. Although in some cases, some states actually do let that justice finish out their term even when they hit that mandatory retirement age. They just can't run or be appointed to it again. In most cases, terms are 6, 8, or 10-year terms, and 33 states have a mandatory retirement age, but some states have both fixed terms and a mandatory retirement age. Rhode Island is similar to SCOTUS in that it's the only state with lifetime appointments and no mandatory retirement age. Massachusetts, New Hampshire, and New Jersey don't have fixed terms, but they do require retirement by age 70. So not quite a lifetime appointment, but fairly close to it. And there's also a lot of variety in how state Supreme Court justices are chosen and or kept on past their first term. So you have partisan elections where the justices actually run as Democrat, Republican, Libertarian, Green, whatever the case may be. There are nonpartisan elections where they're listed on there, but they don't have any sort of party affiliation. Also have legislative elections where, and this is not a very common one, where the state's legislature actually chooses the Supreme Court justices. You also have gubernatorial appointments that are confirmed by another government body where the governor can just choose whoever they want. And then there's also an assisted appointment method where the governor picks from a list and they have to pick from that list, although they can't say, in some cases, they can say, I don't want any of those candidates. Get them out of my face. And then whatever body it is that gives them that list would have to come up with another list. I mean, it depends on the state. They all have little nuances that are different from each other. But those are the 5 basic ways that state Supreme Court justices are chosen. And 38 states require the justice to reappear on the ballot at the end of their term for election. So 19 states have retention elections, and that is, you might be familiar with it, voting on it yourself, where it's simply, do you want to retain this justice for this next term of however many years? You say yes or no. They're not actually running against anybody. You're just choosing, I want this person to come back, or nope, get them out of here. They're a bunch of bums. 12 states have these justices participate in nonpartisan elections in order to get re-elected to the bench. 5 of the states have them participate in partisan elections. Michigan has a specific method called the Michigan method, very aptly named, where they combine a partisan candidate selection process akin to a primary, but then the general election is nonpartisan. And then Montana runs justices in a nonpartisan election if they have an opponent, but if they don't have an opponent, then it becomes a retention election. So yes or no. And then in 8 states, justices do not stand for an election to earn a subsequent term. So That's comparing SCOTUS to Supreme Court justices. Well, now let's look back at SCOTUS again specifically. What are some of the arguments made for and against SCOTUS term limits? So just general camps here will have lifetime terms versus fixed terms. They don't necessarily the people who support fixed terms don't necessarily all agree on the same exact specifications. They might not necessarily agree on how long that term should be, but just for the sake of making this not complicated, just lifetime term camps versus fixed term camps. So some of the debates that are had about this whole topic. What would lead to less politicization of SCOTUS? Would lifetime terms make it be less political than these proposed fixed terms, or would these fixed terms alleviate some of that political posturing? Because ideally, obviously, we'd all like to have, well, most of us at least would like to have a judiciary that is not beholden to partisan politics. Now, some people think that justices are beholden to it, while some people don't necessarily think that. And some of that is partially based on political views. For some people, if you have a similar ideology to whatever the ideological majority on the court is, you might think that they're not being political because hey, they share my opinion. Of course, they're just being unbiased. They're just following the law. And if your ideology does not comport with theirs, then you're probably going to see them as more political. But in any case, what would lead to less politicization of SCOTUS? So for lifetime terms, according to the framers of the Constitution, like Alexander Hamilton, lifetime terms insulated justices from political considerations. They didn't have to worry about, my reappointment year is coming up. I have to make sure that I do what the president and Congress would prefer for me to do so that I get back on the bench. That's the rationale there. Fixed terms, though, in the eyes of these term limit advocates, cuts down on the politicization that we've seen recently. Because these confirmation battles have inarguably been very politically charged, whether you support one side or the other. Now, lifetime terms might make these appointment battles more of an existential issue because if it's lifetime terms, you can't do anything about them being in office unless you actually impeach them. And is impeachment necessarily a viable route, or are they doing something that's an impeachable offense? You have those kinds of issues to consider, but it becomes more of an existential crisis for people who have a vested interest in whether a Supreme Court justice gets nominated or not. You saw it, for example, with the Brett Kavanaugh confirmation battle, and when Merrick Garland, who didn't actually come up for a vote, but when he was not being the whole time when he was not being able to actually get up for a confirmation vote, that was another example of this being an existential issue for a lot of people. But on the other hand, fixed terms might make political battles over confirmation more common. Clearly, lifetime terms don't actually insulate judges from political wheeling and dealing and battles and all that. But does that mean that term limits would make those less common? That's for you to decide. Obviously, I have my own opinion on the matter, but I'm just trying to lay out everything for you so you can come up with your own opinion. Another debate, what would make SCOTUS more accountable? So for lifetime terms, in their eyes, lifetime terms allow for more deliberation by presidents over who to pick because it is a lifetime term. So theoretically, you're going to be picking better candidates and ones that are more accountable because you're thinking hard about, okay, this person is going to be a lifetime appointment. So I really need to think hard about what they believe. At least that's the idea. And also, if they truly are just that bad of a judge, they can just be impeached in the eyes of lifetime term advocates. Now, for those who advocate for term limits, in their eyes, these judges, they eventually have to face a set end to their tenure. And impeachment is not a reliable mechanism to get rid of the judges, and that process would be politicized anyways. So you still have those issues with accountability and politicization. So again, does lifetime terms make SCOTUS more accountable, or do term limits do that? Up to you to decide. What is the best way to uphold separation of powers and checks and balances? What is the best way to keep that balance between powers that the executive branch has, that the legislative branch has, and that the judicial branch has? Would lifetime terms or keeping lifetime terms upset that balance, or would term limits make those issues more apparent? For lifetime term advocates, in their eyes, it insulates justices from the machinations of president and Congress post confirmation. As soon as they're in office, they don't have to worry about president or Congress trying to get rid of them simply because of disagreements over ideology and court rulings. And like Alexander Hamilton said in Federalist Paper number 78, the judicial branch has the lowest ability to uphold its powers compared to the executive and legislative branch, and lifetime terms help balance that power more evenly in that separation of powers and checks and balances aspect. But on the other hand, term limits advocates argue that because of the considerable power that judicial rulings hold, a lifetime term gives too much power to these judges to shape public policy for a long time compared to fixed term presidents and Congress. We've heard in previous cases when the court makes a certain ruling that either the president or certain members of Congress say, well, they're basically making laws because they're interpreting the Constitution incorrectly. And in their eyes, when they disagree with a judicial ruling, they're basically becoming the legislative and executive branch, where they're in effect writing laws themselves and making others execute the laws as they interpret. Obviously, a lot of that is based on your personal political views or Congress's personal political views as to whether they're interpreting the Constitution correctly or incorrectly. But in their eyes, when they disagree with something, it is in effect writing laws as they see fit. Also, term limit advocates argue that judges have just become an arm for the president to have undue influence over policy, and future presidents should have the ability to blunt that by replacing other justices on fixed terms. So, yes, post confirmation, presidents and Congress can't do anything, but term limit advocates argue that there's already basically a litmus test for these judges where they have to meet certain ideological requirements from a president for them to pick that judge and for Congress to confirm that judge. They're basically saying if they don't meet these specific requirements of how they view things like abortion or gun laws or anything else that is very controversial by nature, the president and Congress are already having a prior influence on what judicial rulings are in the first place. And then, real quick, just one last debate to talk about, and these aren't the only debates to be had when arguing about whether we should have term limits on the Supreme Court, but touched on it a little bit just a moment ago. Should every president have an opportunity to appoint a justice? Obviously, lifetime term advocates don't see it that way. Fixed term advocates do think that Supreme Court justices, that president should be able to, each president should have an opportunity to appoint a justice. So is every president entitled to being able to select a judge as a result of being the chief executive of the United States? All these things are for you to decide. I just want to lay them out for everybody to be able to think about. But again, there's all sorts of other debates that can be had about whether we should have term limits for SCOTUS. Now, Other practical considerations for Supreme Court term limits. How long should these terms be for? What is too short and what is too long? Should these be 9-year terms where every justice is starting a new term every year, where it's Justice 1 is starting 2025 and then going to 2034. Justice 2 is starting in 2026 and then going to 2035, so on and so forth. Should these be 18-year terms? What is considered, is 9 years too short? Is 18 years too long? Is there a different way that you can do it? And relatedly, does every justice have their own term dates, or would multiple justices start in a given year? What if three of them had a start date in 2026, and then the next three had a start date in 2028, and then there'd be 6-year terms for the Supreme Court justices? How exactly do you figure all these things out? Should justices only be allowed one term, or can they serve multiple? That's part of the consideration for term lengths as well. If these are 18-year terms, then should it just be one term for the Supreme Court justices? If these are 9-year terms, should they be able to serve a second term? And what if we made it possible for multiple terms, but they have to be non-consecutive? So if we had a 9-year term, they serve from 2025 to 2034. Then they have to sit out for another 9 years, but then they can be pointed to the bench again 9 years later. Should that be part of the equation? Are current justices exempt from would-be term limits? So the 9 justices we have now, they can serve as long as they want, but as soon as they leave office, then that's when a term would start for the next justice. Or are the current justices also going to be subject to these fixed terms? If we implement term limits, do we change anything about how SCOTUS justices are chosen? Does Congress have a bigger role in how they are chosen? Do voters have a larger role? If you compare it to, like we talked about for the state Supreme Court justices, how some of them are partisan elections, some of them are nonpartisan elections. There are some that are an assisted appointment method. So does the president just get to pick whoever he wants, or should Congress be able to send them a list, sort of like the judicial nominating commissions for certain states, where they say you have to pick a person from this list? Does that come into play? Do we change how that works? Or should we have a mandatory retirement age instead? For example, should they be able to, if they get to 70, then they have to leave, or 75, 72, whatever the case may be? Or should a mandatory retirement age be a supplement to term limits, like some states do, where some states have a 6 or 8 or 10-year term, and they can keep serving those until they hit that mandatory retirement age? Then they either have to leave office immediately, or they can serve the rest of that term, but then have to leave office after that. All sorts of these practical considerations that you have to account for, and it's not a straightforward conversation. So it's all well and good to say, it's easy to say that we should have fixed terms. Even if we all agreed that we should have fixed terms for SCOTUS, you have to think about all these other little nooks and crannies to say, okay, we want fixed terms, but it needs to look like this. And then there's might be some disagreement there. For lifetime terms, it's pretty straightforward because they already have lifetime terms. They either have lifetime terms or they don't. But if you were to implement fixed terms, then there might be some disagreement as to how exactly those look. So all sorts of considerations for SCOTUS justices and how term limits would actually look for them. But let's go to the joint resolution by Senators Manchin and Welch to talk about how they address some of those practical considerations. So how have those two senators addressed these considerations? So this is a joint resolution, not a bill. Congress passing a resolution, not actually implementing a policy or a law of some sort in a lot of cases. Typically, there's not a whole lot of practical difference between bills and resolutions. But in this case, a joint resolution is needed. SCOTUS term limits is not a change that Congress can simply make through a bill because it fundamentally changes a part of the Constitution. And when a joint resolution proposes an amendment to the Constitution, 2/3 of both chambers of Congress need to approve. And instead of sending the resolution to the president for approval like you would normally do for a bill, it is sent directly to the archivist of the United States. And then that archivist then submits that prospective amendment to the state legislatures or special conventions called by the states. More on this later as we talk about what an actual implementation of term limits looks like, or the actual process of implementing these term limits. We're going to talk about that in a little bit. But as for this joint resolution, it's a short resolution that has 8 sections. So the key points are that it would keep SCOTUS at 9 justices. Early on, the Supreme Court fluctuated between 5 and 10 justices until the Judiciary Act of 1869 fixed it at 9 justices. Now, there have been attempts to change that in the past, like with FDR and what was called the court packing bill, which would have allowed him to appoint justices for every current justice that was above, I want to say it was 70 years old. And at the time, that would have added another 6 justices, I believe. So there have been attempts like that before to change the number of Supreme Court justices. But the Judiciary Act of 1869 has fixed it at 9 justices since then. Another key point is that it sets the term for the first justice to start on July 1st of the first odd-numbered year following ratification of this article until June 30th, 18 years after that. And at each subsequent justice's term starts 2 years after the previous justice, which is the next odd-numbered year for the second justice. And then the next justice would be 2 years after that. So you'd have, theoretically, the first justice starts in 2027, the second justice starts in 2029, third one starts in 2031, so on through all the other justices there. Current justices serving before the ratification of the article would still be able to serve as long as they want until they are mentally or physically incapable, die, or impeached. However they leave office, they are not going to be, the current 9 are not going to be subject to the Supreme Court term limits if they were to be implemented. Terms, however, would begin every 2 years, regardless of when they leave the bench. So, for example, if Amy Coney Barrett's seat were to have a term start in 2029, but she serves past that point, she serves into 2032 or whatever, and then she decides to retire. The justice that would be filling in her seat would finish that term. They would not get the full 18 years because technically that term for Amy Coney Barrett's seat started in 2029. But they would finish out the rest of that term. And then 18 years after 2029, 2047, that's when the next justice would begin their term. So, like I said, when a current justice retires, the newly appointed justice would serve the remainder of that 18-year term. Now, what would it actually take to implement SCOTUS term limits? So again, this has to be done through an amendment to the U.S. Constitution. Congress and President cannot pass a bill that fundamentally changes an aspect of the Constitution like this. And even if Congress and President could pass a bill, that would call into question whether checks and balances between them and the judiciary are being respected. And then if somebody doesn't like the bill and they try to challenge it and bring it to the Supreme Court, will the Supreme Court then strike it down and say it's unconstitutional? You have all these issues to consider. But in any case, it's not going to be a bill. It can't be a bill. So it has to be this joint resolution that Senators Manchin and Welch have proposed. Or if somebody else proposes a joint resolution that would propose an amendment to the Constitution. So how do you amend the U.S. Constitution? We had an early episode of the podcast that went over this. So an amendment has a formal method of proposal and then ratification that's much different from regular bills and resolutions. There's two methods for a proposal. You either have 2/3 of the U.S. House and the U.S. Senate agree to the bill, or you have a national convention called by Congress at the request of 2/3 of the state legislatures. They can do it that way. So if you get past the proposal stage, then you have two methods for ratification. You either have 3/4 of the state legislatures, 38 states, because you have to round it up because 37 and a half is 3/4 of the states, and you can't really have half a state do it. So it has to be 38 states that ratify the amendments, or special conventions called in 3/4 of the states have to agree to it. Now, a survey by the University of Pennsylvania's Annenberg Public Policy Center back in May 2024 said that 69% of respondents supported a mandatory retirement age and that 68% supported term limits. Again, what will those exactly look like? That's not what the survey was trying to get at. It was just trying to gauge general opinion about those things. So the public may largely support term limits for SCOTUS, but that doesn't mean that Congress and state legislatures support those term limits. Now, it's not an inherently a partisan issue per se, but potential partisan interests are at play. Whichever party whose ideology is more in line with the current SCOTUS ideology could be a harder sell for term limits. So right now, SCOTUS is currently more ideologically conservative. It's more to the right. So Republicans may be more reluctant to support term limits. And that's where this term limit exemption for current justices can allay some of that opposition. If you say the current conservative majority is not going to be affected by this would-be amendment, then you might get Republicans to go along more with it. And then it'd be the same way if it was a more ideologically liberal court. It might be harder to sell Democrats on term limits for the court. But again, if you exempt current justices, it might be easier to get them to support it. And then even if Congress supports it, will enough state legislatures fall in line, quote unquote? Because 3/4 of the state legislatures is an arguably even higher bar to clear than the initial 2/3 of Congress that is needed to propose that amendment. Now, you do have there's in recent years been more uniformity between state level Republicans and Democrats, or between state level Republicans and federal level Republicans, and uniformity between state level Democrats and federal level Democrats, but there's still going to be disagreements here and there. And even if the public really supports this, these would-be term limits and mandatory retirement age, does that mean that Congress or state legislatures are going to listen to them? Because the public might be really on board with these things, but if they don't, for lack of a better term, threaten Congress and state legislative members with, hey, if you don't pass Supreme Court term limits, we might not vote for you. These congressional members and these state legislative members might not be responsive to that. They have a lot of other fish to fry, so to speak. So if the public can be really supportive of something, but if they don't really pressure people that are in office to implement something, then these people in office might not really do anything about it, especially if they don't actually support these term limits for SCOTUS justices. So in any case, it's going to be a long road ahead to getting term limits ratified, however those look. So even if Joe Manchin and Peter Welch are successful in getting 2/3 of the U.S. House and 2/3 of the U.S. Senate on board with the amendment, then you still have to go through the state legislatures, and who knows how that will end up. So a lot of things to resolve there, or if another potential amendment that deals with SCOTUS term limits gets proposed, that makes a little bit of change to what Manchin and Welch have proposed. So lots of things to think about. And in any case, that is the end of today's episode. And as always, thank you very much for listening in. Let's end off on a random question of the day, just like we always do. Random question of today is: what's common grammatical or pronunciation mistake really grinds your gears? I'll tell you something that really drives me up a wall. Nuclear and nucleus, for one. People say nuclear and nucleus all the time. It's really not hard to say nuclear or nucleus, I don't think. Uh, but actually, what really bothers me is when people say, and usually it's typed up, it's when they say should of, would of, could of. If you look at the contractions of could have, should have, would have, there's nothing about those that indicates that it's should of, it's should have, not would of, it's would have, not could of, it's could have. It says, I mean, there's lots of uh, things that really aren't that important in the grand scheme of things that get on my nerves. But you know what? I probably do some things that seem rather innocuous that bother other people too. So I don't know. But in any case, let me know what you think about that or what your answer to that question is. And whatever you think about the content of today's episode, please be nice, though. I don't like mean words being thrown at me. Be nice. It could all be a little bit nicer to each other. And that includes myself. So, uh, in any case, once again, thank you for listening. Links in the show notes for Facebook, LinkedIn, Matchmaker FM profile if you want to be a guest on this podcast or if you want me as a guest on your podcast. Email at paulraderwrites@gmail.com. My book on Amazon, Why Independents Rarely Win Elections and How They Could Become More Competitive. And I'll leave you on that. Merry Christmas to all of you who celebrate or any other holidays that you celebrate around this time of year. And until then, take care.